Some attorneys only do trust and trust administration. Others only do litigation, feeling those are two separate. And some like doing both. I know you do both. Explain why you feel that helps you for your practice.
Absolutely. So I am fairly unique. There are a few of us out there that do both the planning and litigation over the trusts, but it's very rare. So a few years ago, maybe 6-7 years ago, one of my trust administrations was getting challenged, and there was an opposing counsel. And before I just referred it out and got scared of litigation, I thought to myself, I know the law, so why don't I talk to this guy? And after a few months of litigating that case, I realized I know what I'm doing. I went up against a 40-year guy, and this was pretty straightforward. And then I started litigation. And my very first case happened to go all the way to trial, and we won that trial. And since then, we've conducted about 100, maybe a little over 100 litigations. We've only lost one trial. Not to mislead the public, many cases do settle. In fact, the vast majority should settle. But on those that do go to trial, we're very efficient at what we do. Now seeing the trials and what people allege and how discovery and evidence comes out makes me a much better planner than I was, and than most other attorneys. I know exactly what people are going to fight out over. As an example, very common fact pattern with estate plans is putting a child as a joint tenant on your bank account to help pay your bills. That is probably one of the #1 reasons we're in court litigating, is the joint tenant accounts, and one child benefited more, and siblings don't like that. So that has now educated me to guide clients away from that as an example. But being the litigator makes me a much better planner.
I agree. I know when I saw another attorney in Long Beach who's a prominent litigator, they also estate planning, explained why they work better, and he had a particular topic, and he showed how certain verbiage in his documents, his template, let's say, was as a result of litigation he was involved with, and he would see, over and over again this problem and decide to prevent it with the documents. Ideally, the document is meant to eliminate or reduce litigation, right? That's the whole point of it.